Judge, it might be confusing, but Mr. DeBenny, he has a pending probation
Turn that
violation.
microphone toward you.
It might be confusing, Judge. He has a pending probation violation, plus he has other charges. He'll be pleading guilty to the probation violation, subject to Your Honor's approval. His sentence will be placed into effect. He will serve 1 year and then be released back on probation. On the new charges, he will be pleading guilty to theft between $2,500 and $10,000. He'll be getting a 6-year sentence, all suspended but 1 year. And that will run concurrent with his probation violation. He'll also be pleading to simulation of $10,000 to $60,000. He'll be getting an 8-year sentence, suspended all but 1 year. And he is to make restitution on the probation violation, restitution on both of those cases during the pendency of his probation. He'll have random drug screens. He'll have to pay restitution within time limits. So the total sentence would be 8 years, suspend all but 1 year, and then 7 years supervised probation.
All right, Mr. Devaney, raise your right hand. Let's place you under oath.
Yes, ma'am.
State your full name for the record.
Christopher Michael Devaney.
Mr. Devaney, you're here today on 3 different types of offenses, and I'm going to deal with your probation violation first. You understand that if you are charged with probation violation, you have the right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had actually violated your probation.
Yes, sir.
You understand that you would have the right to have a lawyer and have one appointed if you could not afford your own.
Yes, sir.
You understand that if you went to that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by pleading guilty to violation of probation, you waive your right to that hearing and that appeal. And all I'm going to do is revoke you to serve your sentence for 1 year, day for day, and then return you to probation.
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you wish to plead guilty to the charge of probation violation under these agreements?
Yes, sir.
Then I find you guilty of violation of your probation order that you be revoked to serve 1 year, day for day, and then return to active probation. In these other cases, in docket number 2025-CR139, count 1, you're charged with theft of property, and count 2, you're charged with criminal simulation. Have you seen or been shown a copy of those charges? Talked them over with Mr. Overton, you and he discussed the range of punishments you're facing as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated that you want to enter a plea of guilty to those charges according to this agreement. Do you understand that you have a right to plead not guilty and to have a speedy and public trial by jury of those charges?
Yes, sir.
You understand that trial you would have the right to have a lawyer and have one appointed if you could not afford your own?
Yes.
You understand at trial you would be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, sir.
You understand that if you went to trial, you and Mr. Overton could confront and cross-examine every witness the state called to testify against you, and you can bring in your own witnesses by the use of a subpoena.
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by entering this plea, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out on these cases.
Yes, sir.
But you understand that's going to result in convictions that are going to be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime.
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you want to plead guilty according to this agreement and waive your right to a trial and to an appeal?
Yes, sir.
Do you understand if you plead guilty, the court of the state could ask you questions about these offenses, and if you answer the questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we determine that you were lying under oath?
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
You understand that I can't accept your pleas unless I'm satisfied you are in fact guilty and there is a factual basis to support them.
Yes, sir.
Then, are you guilty of the count of theft? Are you guilty of theft?
Yes, sir.
What did you take? What did you do overall, I guess it would be? Why are you in jail?
It would be for out on my own business, and a customer sent me some money, and I didn't complete the job.
All right. And then there's a second count of criminal simulation. Tell me, are you guilty of that?
Yes, sir.
What did you do to in that particular case?
It was all stems from the same. The same.
General Wojciechowski is going to let me know what the facts would be. The criminal simulation is a little different than theft. So what is the? I tell you what. Step aside and let her stand at the podium and tell us what the facts are. So.
Judge, on November 14th of 2024, Mr. Devaney took a check over to First Federal Bank that had been made out to him for $9,850. Then on the 15th, he withdrew that check from the bank. This check was a fraudulent check. It had been actually made out to a different, to a like townhouse for a rent, and had not been made out to Mr. Devaney. It also had been made out to a separate amount. So the theft and the criminal simulation come from the altering of the check and the theft of the money. The bank actually did give Mr. Devaney the opportunity as well to try to repay the money, and he chose not to do that. And that's the basis of the theft and the
Thank you. That
criminal
explains it
simulation.
for me. All right, Mr. Devaney, you understand that's what the state's evidence would be if this case went to trial?
Yes, sir.
You still wish to plead guilty according to this agreement?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
Feel like Mr. Overton's done a good job of representing you competently?
Yes, sir.
Mr. Overton, do you know of any reason he should not enter these pleas?
No, Your Honor.
Then, Chris, anything further from the state? Right, that is part of that condition. I didn't announce that.
In
so.
the first case.
All right. I failed to note that on the probation violation order, but there is a requirement that after you have served your 1 year day for day, that you will pay restitution within 90 days of the reinstatement of your probation. And that will be in full, and that will be a zero tolerance. What that means is that you must pay it within 90 days. If you don't, for any reason, then you'll go back to jail to serve the balance of that sentence. You understand that?
Yes, sir.
All right. Then, in docket number 2025 CR 139, upon your plea of guilty to count one, I find you guilty of theft, order that you be sentenced to 6 years Tennessee Department of Corrections to serve as a range 2 offender that will be suspended to supervised probation after you serve 1 year day for day in the Dixon County Jail. You're ordered to have drug screens at least one time per month and have zero tolerance for your drug screens. If they're positive, one positive drug screen sends you to prison. You're ordered to pay restitution in the amount of $9,850 to First Federal Bank with a minimum of $100 per month towards restitution. That will be concurrent with your probation violation. In count 2 of that indictment, you're found guilty of criminal simulation, sentenced to 8 years, Tennessee Department of Corrections to serve as a range 2 offender, suspended to supervised probation after serving 1 year day for day in the Dixon County Jail. Those same conditions will be required as in count 1. This will be concurrent to count 1 and in your violation of probation for an effective 8-year sentence with 1 year to serve day for day and 7 years on probation. All right. Thank you.
Thank you, Your Honor.
Sign there. Your Honor, subject to the court's approval in 22 CC 2025 CR 210, the defendant, Mr. Cord Cameron, will enter a no contest plea to the DUI fourth offense, which is charged by information. He signed the waiver of indictment, and he is signing the plea of guilty, or excuse me, the plea of no contest, Your Honor. On this, his punishment will be 4 years to serve with TDOC at range 3, 45% release eligibility. He has a $3,000 fine and costs and he has a loss of license for 8 years. And this will run concurrent to a General Sessions case, GS 22CR 1127, as well as concurrent to a Davidson County case 2021A 432. There were other charges that are in bind over, but these are being nollied, again, subject to the court's approval through a separate order. And beyond that, I've discussed the DUI enhancements with the defendant. He understands those and is signing the notice of DUI punishment. I believe that concludes it, Your Honor. I'm handing up this paperwork. Thank you.
All right, Mr. Cameron, raise your right hand. Let's place you on the oath. Mr. Cameron, if you'll state you can put your hand down, but state your full name for the record.
Cord James Cameron.
Mr. Cameron, I'm going to go through your rights regarding these issues, and I just need you to make sure that you understand them and that you make a verbal response so we can record everything that's being said, all right? Do you understand, first of all, that you are charged here, or you're not charged, but you're proceeding today under what we call a criminal information? Every person who is charged with a criminal offense that carries the possibility of incarceration has the right to have their case reviewed by the grand jury of the county in which it occurred. The grand jury is an independent body that reviews the evidence. They only hear one side, but they determine whether there is sufficient probable cause to even return an indictment. And if they do, then it comes to the circuit court. To expedite the disposition of your case, you can waive the grand jury's presentation of that case or their consideration of that case and proceed on what's called a criminal information, which is what we're doing today. But do you understand that you're waiving your right to have the grand jury review this case?
Yes, sir.
Do you also understand that what you're charged with and that this case, as Mr. Talbot has explained, is going to resolve several different things. Some other charges that are making their way up through the system are going to be dismissed, and you're going to be entering a plea to serve some time in prison. You understand that?
Yes, sir.
Do you understand everything you're charged with? Do you understand the nature of this charge? And have you talked it over with Mr. Talbot? You and he discussed the range of punishment you're facing as well as any possible defenses you might have.
Yes, sir.
While it's indicated that you want to enter a plea, is this a plea of no contest? Yes, a plea of no contest. That means you understand what the facts are going to be. You're not going to admit you did anything wrong, but you're not going to contest the state's evidence. And they're going to tell me what their evidence would be at trial, and it's that evidence that I will use to support a finding of guilt in your case. Do you understand that?
Yes, sir.
You understand, however, that you have a right to plead not guilty and to have a speedy and public trial by jury in this court.
Yes, sir.
You understand you would have the right to have a lawyer at trial and to have one appointed if you cannot afford one, and we've already done that with the public defender.
Yes, sir.
Do you understand at trial you would be presumed to be innocent until such time, if ever, the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of any crime?
Yes, sir.
Do you understand that if you went to trial, you and Mr. Talbot could confront and cross-examine every witness the state might call to testify, and you could bring in your own witnesses by the use of a subpoena?
Yes, sir.
You understand that you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by pleading guilty, or no contest rather, by pleading no contest, you're waiving your right to contest the guilt or innocence, and you're waiving your right to a trial and to an appeal. And all I'm going to do is approve what your lawyers worked out.
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you understand that's going to result in a felony conviction? But that conviction will be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes, sir.
And it's been explained to me that your lawyer has gone over with you what we call the DUI enhancement provisions of the law, which is that every conviction results in a larger, more harsh punishment the next go-round. You understand that?
Yes, sir.
You understand everything I've explained to you thus far?
Yes, sir.
You want to plead no contest and waive your right to a trial as I explained?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No.
You understand that I can't accept your plea unless I'm satisfied that you are in fact guilty and that there are facts to support it.
Yes, sir.
And I want you to listen as the state tells me what their evidence would be if this case went to trial.
Your Honor, if this would go to trial, the state would show the honor about June 30th.
All right, Mr. Cameron, I'm not asking that you agree with those facts, but do you understand that's what the state's evidence would be if you went to trial?
Yes, sir.
You still wish to plead no contest according to this agreement?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
You feel like Mr. Talbot's done a good job of representing you competently?
Sir.
All right, Mr. Talbot, do you know of any reason you should not enter this plea?
No, sir.
Anything further from the state? Then Cameron, Corey J. Cameron, and docket number 2025 CR 210, upon your plea of no contest to count one, I find that you are in fact guilty, sentence you to 4 years in the Tennessee Department of Corrections to serve as a range 3 offender. You are to pay a $3,000 fine and cost. Your license to drive is suspended for 8 years. This sentence will be concurrent to your general sessions violation of probation, as well as your Davidson County violation of probation. And the remaining, there are other cases that are being nollied as a result of that plea, and I have signed that order to dismiss those other cases. All right, thank you.
Thank you, Your Honor.
Yeah. Mr. McCoy, I looked through your file, and you were one of a multiple defendant case that is set for trial in January of this year. So it's important that we go ahead and get you with an attorney who does not have a conflict. I have gone through, the problem that we run into, for your explanation, is because there are like 27 defendants. Every time we appoint an attorney, that creates a conflict so that the attorney can't then take another case. So the local bar has been exhausted. Those who practice criminal law have all accepted an appointment. We've reached out to surrounding counties and gotten other attorneys, but that's a limited number too. But I have determined that an attorney out of Dixon County, who's an experienced, Cheatham County, Sonny Stevens, is going to be appointed to represent you. She's being notified that she will be your lawyer. She should be able to get you ready for disposition or for trial in the January trial date. But that's where we are. I just wanted to let you know that that will take place.
The problem I have is I've asked multiple times about the discovery and what the state has against me. I've been here almost, 3 months shy of 3 years, and I have not yet seen what the state has against me. And also, I asked my attorney if I had a search warrant, and he says he didn't see one. And I've asked multiple times for a suppression hearing, and I still haven't had a suppression hearing.
Well, we will, Ms. Stevens will be notified of that as soon as she can talk with you and examine the files. And she will consult with some of the other attorneys who have been in these cases representing the other people longer, and therefore she can get that information as well from them. And then she will be able to file that motion to suppress if that's what needs to be done, and I will set it for a hearing. So if there's a need to file that motion, we'll do that. But I think that's the key, is she can get the information pretty quickly about the discovery, and I'm sorry that you've not been able to get that information from your other attorneys. But Ms. Stevens is a very capable attorney. She will get with you and get that information and then file the motions that are necessary. All right?
Yes, sir.
I just wanted to tell you in person what we had done, okay?
Thank you very much.
All right. Thank you.
What you're watching here is not about emotion, excuses, or explanations. It's about control of the record. Judges move carefully in cases like this because every answer given under oath locks the defendant into a legal position that can't be undone later. The judge's calm, methodical tone isn't patience, it's precision. This is how courts protect verdicts from appeal and ensure that responsibility is clearly documented. The most important thing to understand is this: once a defendant pleads guilty or no contest, the courtroom stops being a place of argument and becomes a place of enforcement. At that point, intent, stress, and personal circumstances largely stop mattering. What matters is compliance. The first major mistake the defendant made in this case happened long before this hearing: violating probation. Probation is not a suggestion or a second chance built on trust. It is a conditional sentence. Once violated, the court regains full authority to impose the original punishment without leniency. Judges react firmly here because probation violations signal unreliability, not remorse. The second mistake was financial noncompliance. Courts take restitution extremely seriously. Paying late, partially, or eventually, is treated the same as not paying at all. From the court's perspective, restitution deadlines are tests of discipline. Miss them, and the system assumes future orders will also be ignored. Another critical mistake defendants often make, and this case shows why judges warn so carefully, is answering factual questions casually. Every statement made under oath becomes evidence. Even attempts to minimize conduct can later support harsher outcomes or perjury exposure. Judges slow these moments down because defendants frequently harm themselves without realizing it. Notice what emotionally does not matter here: whether the defendant feels the punishment is harsh, whether the situation got out of hand, whether there was no intent to harm. Those explanations may matter socially, but they don't reduce legal responsibility once guilt is admitted. What does legally matter is tone, clarity, and acceptance of conditions. Judges look for signs that a defendant understands the structure they're entering. Compliance language matters. Hesitation, confusion, or deflection raises red flags, not because the judge is angry, but because future supervision depends on predictability. This is why the judge explains rights so thoroughly. Once waived, they're gone. Appeals become limited. Sentences become fixed. Supervision becomes strict. The real-world consequence here isn't just jail time. It's years of structured oversight, zero-tolerance conditions, and instant penalties for mistakes that might seem minor outside the courtroom. One missed payment, one failed test, one ignored instruction. That's all it takes. The lesson for anyone watching is simple. Court is not the place to improvise, explain, or negotiate emotionally. It is the place to listen, answer precisely, and comply exactly. Judges respond calmly when defendants respect the process, and decisively when they don't.